like to welcome you on this debate today of Constitution, a living, changing document, or fixed by its authors. Speaking for the Federalist Society is the Honorable Gerald Walpin. Mr. Walpin is the former Inspector General of the Corporation for National and Community Service. Quick background is, Mr. Walpin was nominated to the post by President George W. Bush, confirmed by the Senate, and sworn in office in January 2007. He led the Office of the Inspector General, an independent federal agency charged with oversight over the taxpayer-supported corporation and its service programs, including AmeriCorps, Volunteers in Service to America, and Senior Corps, serving in this role until 2009. He served as a lieutenant in the Air Force Judge Advocate General. His career included a 5-year stint as Chief of Prosecutions for the United States Attorney for the Southern District of New York. Mr. Walpin has represented a wide range of clients, including large public corporations, security brokerage firms, accounting firms, law firms, banks, and lender liability claims, and individuals, both American and foreign, in security litigation, employment litigations, criminal prosecutions, and investigations by the United States Security and Exchange Commission. Mr. Walpin recently published a book entitled The Supreme Court versus the Constitution. You don't have to be a lawyer to understand how Supreme Court justices have substituted their own elitist views for constitutional guarantees that protect the average American securities and values. Mr. Walpin will be doing a book signing at the end of the program, and anyone desiring to buy the book will be able to do so at a discount for $11. Speaking on behalf of American Constitution Society is Professor Enrique, Guerra-Pujol, an associate professor in Honorary law. He teaches constitutional law, torts, and product liability. His main areas of research are the evolution of conflict and cooperation, formal mathematical modeling, and the application of evolutionary game theory to law. Professor Pujol is a member of the American Association for the Advancement of Science and has published more than 20 scholarly papers in the U.S., Australia, and Caribbean law journals. To moderate this debate, I would like to introduce Professor Terry Day, our Professor of Constitutional Law. Professor Day needs no formal introduction, being a longtime faculty member at the law school. She will explain the format, and we will start the debate. Thank you.
Thank you. This is very exciting, and I'm so happy to see so many constitutional law students. The format today will be that Mr. Walpin will begin. He will make his presentation for 17 minutes. Professor Pujol will then respond for 20 minutes. Then Mr. Walpin will rebut Professor Pujol's response for 3 minutes. And then after that, we will open up the floor for questions. So we're ready to begin.
Good things may come in small packages, but you wouldn't see me there. I really appreciate being invited down here. I left New York today, and the plane had to be de-iced, so you can imagine how great it was to come down here and be with you in this warm weather and seeing such bright, beautiful, handsome faces. I wrote this book, Supreme Court versus the Constitution, because I, like most of us, love this country. My book spotlights the unique gift that our founding fathers gave to us, a written constitution that was intended to guarantee that this country would be forever governed by the rule of law, not the rule of individuals. That is not an empty phrase, rule of law. World history has been full of autocrats and tyrants who ruled on the basis of their own bias and self-interest. Our written constitution and the checks and balances it created were intended to prevent them. And while not perfect, the checks and balances have worked pretty well, with Congress checking the President checking the Congress, and the courts checking both the President and Congress, and the people through elections also check Congress and the President, because all of them are subject to election. But there is nothing similar with regard to the third branch of government, the courts, and especially the Supreme Court. That as, does everybody hear me without a mic, by the way? I usually speak loud enough. My book details how the Supreme Court can have a very substantial impact on all Americans' rights, security, and values. And yet, the Supreme Court is not subject to any check or balancing by other branches of government, nor subject to being ousted in an election. Our country's founders intended that the rule of law, not what they called then the rule of men, but I call the rule of individuals now for obvious reasons. They intended the rule of law would govern Supreme Court justices as well as the President and Congress. And let me ask here, raise your hand, how many of you believe in the rule of law? Well, it's most everybody. And I will attribute those who didn't raise their hand to being lazy. Now, what does the rule of law mean as applied to justices? It means that they should not decide cases based on their personal views, the personal views of those who happen to be justices, but on what the Constitution has in it, and what our Constitution's authors intended by the words they used in the Constitution. Thus, justices must uphold laws enacted by legislatures that do not violate the Constitution, whether or not the individual justice approves of the law. And likewise, they must declare unconstitutional those laws that violate the Constitution, no matter that they personally like the law. Most Americans pay attention and participate in the choice of presidents, senators, and congresspersons, but few Americans involve themselves in the choice of Supreme Court justices. Yet, through the years, the Supreme Court has shown that it has had much greater permanent power to affect our lives than Congress and the President. What they decide cannot be changed unless the next or later Supreme Court decides to change it, which is very seldom. And recognizing the possible misuse of court power, our Constitution's authors stated what they expected of judges. For example, in the Federalist Papers, which we all know is the Bible for the meaning of the Constitution, it states in it, the established form in the Constitution's wording is binding, and it's the judge's duty to enforce it. And that's why every Supreme Court justice, as well as lower judges, when they take their oath of office, swear to enforce the Constitution. Thomas Jefferson stated, and I quote, "The limited Constitution we have created to bind down those we are obliged to trust with power, making us all bound down from mischief by the chains of the Constitution." Chains of the Constitution, that were his words to show that we are all limited by what the Constitution says. Now, I want to give you an example of activist judges violating the original words and intent of the Constitution and the Bill of Rights that I believe everyone here will agree with me is a terrible example of how justices can go wrong because they want to base it on their personal views rather than on what the Constitution says. The 14th Amendment was enacted in 1868. No state shall enforce any law which shall deny any person equal protection of the laws. In 1896, the Supreme Court had before it a case called Plessy v. Ferguson. Mr. Plessy was 7/8 white and 1/8 black. Louisiana police arrested him when he wanted to sit in the railway coach reserved for whites. Louisiana convicted him. It went up to the Supreme Court. 7 justices in the majority agreed that the object of the 14th Amendment, as they wrote in their opinion, was to enforce the equality of races. And yet, those 7 justices upheld the conviction of Mr. Plessy based solely on their personal views, which overcame, because they were personal views of segregationists, which overcame what the Constitution, the Bill of Rights said, and what was intended when it was enacted. Now, most of us here will say, oh, that was a terrible decision, but what justices do today in overruling the Constitution and substituting their personal views, if I agree with it, then it's okay. But you can't have it both ways. And it's not only because it's hypocrisy, but because today's minority opposing the decision you like may well be tomorrow's majority. And in the last 5 decades, without any changes in the Constitution, the Supreme Court has changed the law of the land by claiming that words in the Constitution, understood by the authors of the Constitution to mean one thing, suddenly are construed to mean the opposite, affecting, and these affect each of us in our values, how we live, and the security that we live under. Let me give you some examples. I have many in the book that I detail, but in the short time I have here, I'm just going to outline some of them. Abortion. For centuries, it was illegal and criminal in this country. Suddenly, Roe v. Wade was announced by the Supreme Court, finding a constitutional right to abortion based on a constitutional right of privacy, which they suddenly discovered in the Constitution, although you can't find it with your eyes. And several times before, the Supreme Court had held there was no general right to privacy in the Constitution. Second example, death penalty. The Bill of Rights copied the English rule against, quote, cruel and unusual punishment. The death penalty was allowed in England, and for 2 centuries in the United States, as held many times, it was not cruel and unusual punishment. Suddenly, the Supreme Court announced decisions, which are detailed in my book, and you will be amazed when you look at them chronologically, how, for example, one death penalty is thrown out because there was discretion in the jury, and another death penalty was thereafter thrown out because there was no discretion in the jury. But essentially, what they were holding, that the term cruel and unusual punishment is to be reinterpreted to say it means almost no death penalty. Take another example, life without parole. It was allowed for centuries. Suddenly, the Supreme Court discovered that the Constitution says it shouldn't be allowed for, even though a jury had passed on it, even though courts in the state had passed on it, it shouldn't be allowed for a youth who was even 2 months under 18, who had committed a horrific crime of rape and murder. Where did they find it? It's not there in the Constitution. Then there's the question of the example of recognition of God. The Declaration of Independence recognized God as the source of our rights. So did Jefferson, Benjamin Franklin, and almost every president from the early America through Abraham Lincoln, FDR, and even President Obama. Because in times of peril, each one of them spoke and wrote of prayers to God to save and protect the United States and protect our soldiers when they're in battle. our money, which we use daily, and the motto that was approved by Congress, "In God we trust." Yet, in the late 20th century, the Supreme Court ruled, and I give you one example here, that a student chosen by her classmates to give a non-sectarian, non-denominational talk at a football game couldn't give thanks to God for what they all had. Another two decisions that I want to give you as examples, they involve letting criminals go free. For 200 years, a confession by a defendant has been held admissible as long as the evidence shows that it was not given under compulsion. And the Supreme Court has many times stated that the best evidence of guilt is a confession. And the Supreme Court has for several times rejected any special litany or any special words to give to a person in custody before what he says can be used in court. They reject it. Suddenly, 200 years later, you get the announcement of the Miranda Rule, setting forth a litany of words that doesn't appear in the Constitution, and as I show in the book, as a practical matter, has absolutely no effect other than to release guilty people. Similarly, search and seizure. Again, the best evidence of guilt is physical evidence of a gun or a body, for example, that is by chemical or expert evidence attached to the defendant. You can read the Fourth Amendment all you want. It's just, I think it's 54 words. There's nothing in it that excludes this such evidence. Suddenly, however, the second half of the 20th century, the Supreme Court invented an exclusionary rule, which the court had specifically previously rejected. The Constitution didn't change. The other areas that my book go into, some of them, the same degree of changes. On pornography, on child pornography, on violent computer games, on horrible animal cruelty movies. They followed their own personal view that led to inconsistency in their rulings. For example, one of them, a minor under 18 is mature enough to decide for herself without parent involvement to have an abortion. But, the Supreme Court says, that same minor, because of the lack of maturity, cannot be subject to a death penalty for horrific murder or rape. Now, the issue I raise in the book and that I raise here is not whether you believe in or oppose abortion, death penalty, Miranda rights, or any of the others that I've mentioned and that I set forth in the book. But the question I raise, who should decide it? State legislatures have the right to do away with or keep the death penalty, abortion, etc. Should state legislatures, elected by the people, congressmen elected by the people, the president on signing bills elected by the people, decide whether or not it is good for America to have these rules, a legislative decision, or should it be done by 5 unelected justices? I see that I have 1 minute left. I'm going to save it for the other 3 minutes and keep it for rebuttal. Thank you for listening to me.
technology going. I have a fun PowerPoint for everyone. First of all, I have to thank first of all, I want to thank, it's just an honor for us to have me to be on this panel, Gerald Walpin, because he's actually done, I admire him a lot. He's a great American. He was a U.S. attorney in New York, prosecuted one of the most important cases, really, the Cohen case, a great case. He's a very, I think he's a lot of intellectual integrity, supporting the nomination of Sonia Sotomayor to the Supreme Court. And he was really, I think, unfairly singled out as Inspector General when the Obama administration came into power for exposing corruption and some within the inner circle. And so, I really feel honored to be here and to be on this panel. And let me say that one of the things I love about this is I think that's this is exactly the issue we need to be debating. And the way I put it in my class is, what is the role of judges in a constitutional democracy? But the way Mr. Walpin put it is just as correct. What are the limits on judicial power? That's really an important question that we often overlook by just focusing on abuses of executive power or legislative power. And so I think we're at the right starting point. Here, though, I've been asked to represent the living Constitution side, and in fact, while I'm very sympathetic and agree very much about the concerns that were shared here about abuses, not just of executive and legislative power, but also judicial power, I want to explain just in an honest way why I'm not an originalist, and I have a little footnote, because actually I think we're all originalists, but I'll say why I'm not only an originalist, because I do agree with Mr. Walpin that we need to begin with history, right? And we need to begin with our founding fathers. But for me, that's not the end point. That's just the starting point. And what I'm going to do during my talk is I'm actually going to try to weave in and try to address, as I won't have a rebuttal myself, try to address some of the examples that he gave, which I think are very legitimate concerns. I just want to be, upfront with you guys about that. And he talked, for example, about abortion and, really the right to privacy is not in the Constitution. But I think this is why I'm what I call an originalist plus, right? I definitely want to start with the Federalist Papers. I've taught a seminar on the Federalist Papers. I've read the Federalist Papers. I think it's a great starting point. But the reason why I don't end there is think about privacy. Think about abortion and rights of women. Think about a less controversial example. Think about, or actually just as controversial, the right to marry. But here I'm just thinking about traditional marriage, right? Marriage is also not in the Constitution. But wouldn't it be just preposterous if one of the states were to deny people the right to marry or require everyone to get married through some kind of arranged marriage or lottery system? Think about it, right? This is why we have courts. We have courts to really, and this is the important point. Now, this is not going to address the legitimate concern about abuse of judicial power. There's always that risk. But in the first instance, we have courts to protect our individual rights. And when looking at, the scope of the right to marriage, the scope of, family relations, the scope of what today we might call reproductive rights or right to an abortion, right? We're going to look also at our traditions, right? And I won't have to go into all detail, but when I say that I start with history, I don't end there because I want to look at precedent. I want to look at our country's traditions. I want to look at traditions of other Anglo-American cultures and legal systems. I also think judges, and they often do this, right? Hey, let's look at the consequences of likely consequences of a decision. And I have the et cetera there because there's been a lot of